Hello, everyone. So let's begin our class for the day. In the last class, we discussed about private companies. So what do you mean by a private company? Well, a private company is a company with minimum paid up capital as prescribed and which by its articles, come on everyone, repeat with me, which by its articles restricts the transferability of shares, limits the number of members to 200, and prohibits the invitation to public to subscribe to its securities. When we talk about the second point, that is limits the number of members to 200, there are 2 points that we have read additionally. What are the 2 points? Point number 1, joint members shall be counted as one and the employees will not be counted in the limit of 200. Yes, everyone. Today, the first topic that we are going to start with is public company. Now, first of all, you have to understand that basic difference. Okay, I am not talking anything about the facts and figures like minimum number of members, etc., etc., etc. I'm asking you just one basic thing: public company or private company? Who do you think is more regulated? Is more regulated? Public company, of course. Why? Why? Like, private company has a lot of benefits, oblique privileges, like not required to appoint independent directors. If you're writing this, you can definitely write like this, no problem at all. But even if you're not writing, there's no problem. Later on, of course, we will be discussing a lot of points relating to this. Okay. Now, see, all the points I'm writing are in general. There can be additional specific requirements. Rotation of auditors is not mandatory. I'm just telling you very specific, very general things. Sorry, very specific, very general things, etc. Okay, which means when I am talking about a private company, they operate in a private space. And government is always like, okay, it's their money, let them do whatever they want to. Why ask them this? Why trouble them with a lot of compliances, a lot of burden? Let them do business. It's their money. Even if they're incurring losses, it's fine. Okay. We don't want a lot of information from them, right? So, less disclosures needed, right? Let me write this. Less disclosures needed. You get my point? Okay, ma'am. But when we talk about a public company, then the shares are freely transferable. There are more disclosures. They are exposed to strict compliances. Why? Because, of course, there can be a situation that public companies can go to general public and take their funds. Yes or no? Yes, ma'am. If you are at your home and maybe you just got angry and you want to throw away the things, right? You are breaking your screen, you're breaking your TV, you are trying to hurt somebody. It's all in your private space. You got the TV, you broke it. Will anyone say anything to you? The answer is no. But one fine day you went to a mall and then again you got angry, you have serious anger issues, and again you tried to break the screens which were there, the CCTV which was there. So now you are trying to destroy public property. Will people object, will people stop you? Yes. Why? Because that's public space, that's public property, that's public money which is involved. So in a private company, they don't tell you to do this, they don't tell you to do that. Yes, you have certain compliances, but not many. Right? Why? Because it's your private space, your private money. But when you form a public company, well, then you are exposed to more compliances. You are exposed to more compliances. But what if, ma'am? I have a beautiful idea. I have a beautiful idea. Let's say I form a company ABC Limited. I form a company ABC Limited and took all the money from public. Okay. Took money from public. Why? Because I'm allowed to. Can I? Of course, I am a public company and I can raise funds from public. So I took money from public, I issued them shares, etc., etc. Just like we have Reliance Industries Limited. They have taken money from general public, right? Can they? Of course they can. Now, can they invest in another company? Yes, ma'am. Why not? Why not? If I ask you who can be a shareholder, your answer would be an individual, yes or no? Or maybe a body corporate. And body corporate includes a company. Body corporate includes a company, which means a company can hold shares of another company. Yes or no? Yes, ma'am. What is the problem? Is there any problem? No, of course not. Which means ABC Limited, you are a company, you can buy shares, you can buy shares or invest in another company. Another company could be PQR Limited or maybe RS Private Limited. Yes, it could be. Let's keep some simple names. Why PQRR Honey Bunny? Okay, so we have Honey. Don't go on that Honey. Okay, so let's say we have Honey Limited and Bunny Private Limited. Yes or no? Yes or no? Yes, ma'am. No problem so far. Are we good? Yes, we are good. Okay. Now, this is a background which I wanted to create before we actually go on to this particular topic. Now, I want to know the basics. Public company, minimum number of members, 7. See, if you don't know these basics, this is your last chance. This is actually your last chance to learn these basics. So pay a lot of attention. You must know this. Okay. So minimum number of members, 7. Maximum, no limit. Minimum directors, 3. Maximum 15. Okay. So if you come, like, of course, I want all my students to pass, and even if you want to become an entrepreneur, I believe you should have this professional achievement. But there are many cases. I have seen many students who could not somehow get through, and they have like been a very successful businessman also. So whatever the situation may be, in future, if you feel, see, when the result comes, everyone wants to pass, but if at all the result is negative, it's not in our favor, the feeling is absolutely devastating, right? You somehow feel like, if you have played snakes and ladders, that the last snake at 99 who sits over there, if he bites you, like you fall straight from the end, almost the end, the finishing line, close to the finishing line, back to basics, right? The starting initial, and you have to repeat the entire thing again to get there. So that type of feeling strikes and hits a person, right? So you should always keep this in mind, that if at all I fail, then all this effort I have to repeat. So my effort should be to such an extent that failure is never an option for me. That should be in your mind. So even if you want to do business, failure should never be an option. Always aim that, okay, I want to go to the management field, I want to do something of my own, I want to get into practice, I want to get into corporates, wherever you want to go. This is the first step. Okay, it's that is not a backup plan, that is a plan after this. Okay, now, so if you ask me, if you tell me that, ma'am, I want to, after this, of course, I want to open a public company, can I? Like you asked me, I want to open a private company. I said, fine, go and find somebody. You said, I've already found someone and you wanted to start a private company. Great. Now you have to find 6 other people, right, to form a public company. Okay, ma'am. Ma'am, what about money? What about the funds? Because in private company, you told us that there is no such requirement. So even if I have 500 rupees in my pocket, I can start with a private company and I have to find somebody else. And if I'm talking, or if I'm forming a one person OPC, one person company, that type of private company, then I don't even need another person. I can open it on my own. But what about the fund requirement in a public company? Well, in a public company also, there is no fund requirement. What are you saying, ma'am? That means, again, with 500 rupees, we can open a public company. Why not? You just need to have 7 people. Which means, public company again means a company with such or minimum paid up capital as prescribed, and nothing has been prescribed by MCA. Nothing has been prescribed by central government. Okay, ma'am. So you are trying to tell us that we have read about a type of company which is a private company, like private company wherein we have seen that we have restriction, we have limitation, we have prohibition, right? Which by its articles do all of that, right? In its articles of association, all these things are there. And then we have another type of company, which is a public company. Now, what about the third one? You told that according to section 3, there are 3 types of companies that can be formed and there can't be any 4th type of company. So, we have to form any company as either private, public or OPC. Yes or no? Okay. But OPC is a type of private company only. So, if I look at the broader picture, there are just 2 types of companies: private, public, private, public, private, public. OPC is a type of private company. Okay. So when I talk about private, specifically it's a normal private, or you want to form OPC. Okay. So going by the definition of public company, which is defined in section 2, clause 71, not important to be learnt. Okay. Not important to be learnt. We get to know that public company means a company which is not a private company. The easiest definition ever. Public company means a company which is not a private company. That means this company will not have restriction on transferability of shares. No, the shares are freely transferable. That means this company will not have the limit on number of members to 200. No, it can have n number of members. There is no limit at all. It means that there won't be any prohibition on public to subscribe to its securities. No. If a public company is in need of funds, it can go to public, give its securities, raise funds, give a public offer, IPO, FPO. Of course, it is allowed. So that is a public company. A public company which is not a private company. A public company which is not a private company. Got it? Simple? Very simple, ma'am. Okay. So, public company means a company which is not a private company and has minimum paid up share capital as may be prescribed. Nothing has been prescribed. Is there any problem? No, ma'am. It's not a private company. Shares are freely transferable. No minimum paid up capital requirement. Maximum number of members 7. Maximum number of members, minimum 7. Maximum no limit. Minimum number of directors 3. Are we good so far? Is there any confusion? No, ma'am. Now we will look at something else. What are we going to look at? We'll come back to something very important and very interesting that I was telling you. So we have a company ABC Limited, and it takes money from the public, and thereafter it invests the money in a private company as well as in a public company. That means ABC Limited, you bought shares 60% shares of Honey Limited and Bunny Private Limited. Is that okay? I hope so. There is no problem so far. Yes, everyone. Now, what is happening? Please try to understand the depth of the provision. There is a public company which has taken money from public, and from that funds, it has given the money to a private company. Now, this particular private company, it is not required to give a lot of disclosures. It is not exposed to a lot of strict compliances, right? And the shares are also not freely transferable. The information is somehow confidential, etc., etc. So, public are exactly not getting to know the usage of their funds. Yes or no? Yes or no? So, do you think it is fair enough? Like, because of all this, anyone would want to take this leap? Anyone would think that I have made a public company. If I do all this in this particular company, I have to disclose this. What if I make a private company? I buy the shares of that private company. So this private company is ideally owned by me only. Let me buy 90% shares of that company. What is the problem? Let me give 10% shares to my relatives and all that, right? So ideally this company is owned by this company only. But then this company is not required to give those disclosure, compliances, etc., etc. So the money that I've taken from public is safely parked over here, and I can do all that fraud, and I'm not required to disclose this. I'm not required to no accountability, nothing, etc., etc. Do you think it is fine? It is correct? It is fair? No. So in response to this, there is a line which was added. I'm not exactly writing the line, but the intent and the meaning. Subsidiary of public company will be treated as a public company. The first question over here is, ma'am, what exactly do we mean by the term subsidiary? Although I would have stopped the class and told you the meaning of subsidiary had it been an inter class. In CMA Inter, I do that only. I stop it. Let's first discuss what is subsidiary. But right now you are in finals and you know what subsidiary is. In a nutshell, I can say H Limited holds more than 50% shares of S Limited. H Limited, you are the holding, and S Limited, you are the subsidiary. Yes or no? Yes, ma'am, fine. So if I come back over here, ABC Limited, you hold 60% shares of Honey Limited. Honey Limited, you are a subsidiary, and ABC Limited, you are a holding. Same goes here also. Now, this is a public company, and a public company has bought shares of more than 50% of another public company and made this company its subsidiary. ABC Limited, you are a public company, you have to comply with all the provisions. You have acquired the shares of another public company, which is your subsidiary. They are also a public company and they also have to comply with all the provisions. There is no way you can get away with anything. But a public company, if you make a private company your subsidiary, then you want to get away with the compliances. So for this situation, a law is made that if any private company is a subsidiary of a public company, it will be treated as a public company only. So in the given case, Bunny Private Limited, you will be treated as a public company, which means Bunny Private Limited will not enjoy the privileges, oblique benefits, oblique exemptions conferred to a private company, and will be required to comply with all the provisions and requirements applicable to a public company as if it were a public company. So it will be treated as if you're a public company. Like rotation of auditors, it is mandatory for you. Now you cannot keep one auditor all your life. You have to rotate the auditor. But I am a private company. Why can't I do that? Because you are a subsidiary of a public company and you will be treated as a public company. But my name is private. My name is Bunny Private Limited. It doesn't matter. You can keep your name just like that. But in my articles of association, there is restriction, limitation, prohibition. It doesn't matter. You can keep it like that. So I will not get any benefit of being a private company? No. I have to comply with all the provisions which are applicable to a public company? Yes. You got my point. So Bunny Private Limited, your name will stay as private limited. There are two choices broadly. You can convert yourself into a public company because anyways you're not getting any benefit that's being given to a private company. Okay. So you can convert yourself into a public company. That's option number 1. Option number 2, stay as you are. So your name is intact, your articles are intact, right? But then you will have to comply with all the things, all the requirements, all the provisions that public company has to do. Basically, it talks about the privileges and exemptions. You'll not be granted any privileges and exemptions that a private company will get, used to get. Okay. So, listen here. Provided that a company which is subsidiary of a company, not being a private company, okay, that means subsidiary of a public company, shall be deemed to be a public company for the purposes of this act, even where such subsidiary continues to be a private company in its articles. So it doesn't matter whether you're still a private company, you will be treated, you will be deemed as a public company. Okay, so subsidiary of a public company is a public company. Doesn't matter if this is a private subsidiary, still it's going to be called and deemed and treated as a public company. Is that okay, everyone? Is that clear? Yes. So I hope you got the definition of a public company. Now, because we have read a beautiful term as subsidiary over here, and I really want to explain you what exactly subsidiary company is. So we are skipping this OPC as of now and we will straight away go to this part. On the basis of control. On the basis of control, we have holding company, we have subsidiary, and we have associate. So first of all, we are going to read about these and then come back to OPC. So we have subsidiary company. Now this section number is important. Section 2 clause 87. So far I have told you section 2 clause 68 private and subsidiary 287. Section 2 clause 87. Okay. Now this is a relative concept. Relatives, we actually hate relatives, but that is how it is, right? This is a relative concept, which means if I say you're a boy, well, you are a boy, independent of anything and everything. Yes or no? For you, becoming a boy doesn't, somebody else doesn't have to be anything, right? Likewise, if I say this is a private company, it's a private company. This is a public company, it's a public company. But if I say this is a holding company, well, there's some catch. If I say I am a mother, I'm a mother, not to the whole world, but to my child. So we have a relation. Mother, son, we have a relation. He can be called as son and I can be called as mother. Son to me, mother to him. That is it. Yes or no? Likewise, we have a concept of holding and subsidiary over here. Which means, let's say we have H Limited. H Limited holds 60% shares in S Limited. Then I tell this particular company as subsidiary and this particular company as holding. If I say Mr. X holds 70% shares in S Limited, can I say S Limited is subsidiary of Mr. X? No. Why not? Because when I'm talking about this holding subsidiary concept, well, holding can only be a company, subsidiary can only be a company, rather body corporate, I should say. Okay? It cannot be an individual. Fine. That is why we say subsidiary company, holding company, associate companies, right? So basically, it's not company, it's body corporate, but right now we can understand this. Now, my dear, keep your ears and eyes wide open because this is slightly complicated concept and I want everyone to take a deep breath and understand the concept to the core. Okay, because I am sure you must have explored a lot of angles, but still if you haven't or you have forgotten, this is a good time to explore the different angles of this particular definition. So ideally the definition would look okay, fine, simplified, but then there are many layers attached to it. Okay, so let's explore it. Firstly, we have a company. Now this company could either control the composition of board of directors of another company. Yes? Or hold more than half of voting power of this another company. If any of these two conditions is satisfied, that means one company is controlling the composition of board of directors, condition number 1, or this company is holding more than half of voting power of another company, then this particular company will be called as holding because you're holding, and this particular company will be called as subsidiary. Okay. Okay. Is that clear? Now, when I'm saying holds more than half of voting power, what is voting power? Right now, we will switch this word and we will replace or swap this word with shareholding. With shareholding. So I can say one company holds more than half of shareholding of another company. Okay. So more than 50% of shares of another company. One company holds more than 50% shares of another company. We have simplified the language just for the sake of understanding right now, because to voting power will come a little later. Is that okay? Now, controls the composition of board of directors. What do you mean by that, ma'am? Okay, so we have two companies, right? We have two companies. We have H Limited and we have S Limited. Now, H Limited tells who is going to be the director, who should be nominated, pass the resolution for this, appoint this particular person as additional director. So this company is controlling who is managing, who is the director, who will be in the board. Ultimately, a company is being managed or the decisions are being taken by the board of directors, right? By the board of directors. Let's say there is a school. I decide who will be the principal of the school, and principal ultimately takes all the decisions of the school. Can I say that I'm controlling the school? Of course, yes, ma'am. Why? Because you have the right to appoint the principal. Maybe that right has been given to me by some agreement because I was a promoter some time earlier, or I gave them this or I gave them that. So they have given me the power that you only appoint the principal. So somehow I'm in control of that school. Yes or no? In the same manner, we don't really know. Like, if I tell you, if I give you any example and I ask you, whether this company is controlling the composition of board of directors of this company or not, you'll not be able to tell me. How to check this, ma'am? How do we get to know this? How can we calculate this? No, this is a subjective thing and has not been defined in the Companies Act 2013. Today's homework is to look at the couples. What are you saying, ma'am? This is completely out of syllabus and out of context. Yes. Maybe your parents have always been very good and presentable in front of you, or maybe you have somehow seen the fights of your parents, but every couple fights. Fights means not necessarily shouting at each other or like literally raising hands. No. Fight means having disagreements. How you deal with it, that's completely your call, but no two persons are same in the world. So every couple will have their own disagreements, right? Now, if you look at a couple, okay, now you'll be like, oh my God, look at the wife. Oh my God, she's so controlling. Oh my God, look at his husband. Did you see sorry, guys. Did you see her husband last night? I mean, he's not a red flag, he's a complete red forest. You got my point. How do you get to know that that particular man is controlling his wife? Maybe he's doing something. That something cannot be defined. I cannot tell you that if a man does this, that means he's a controlling man and he controls. In the same manner, over here, we cannot tell you what is control. It is subjective, and if at all it has to be asked in examination, it will be clearly given to you. That this particular company controls the composition of board of directors. What is the relation between both the companies? The companies are holding subsidiary. Why? Because one company controls the composition of board of director of another company, and that is why they established the relationship of holding and subsidiary. Is that clear? Okay. Okay, ma'am, we got it. Now, we have to analyze so many more parameters. So we will start with the examples. So everyone has to write the examples with me. There is no option that you have. Right? Example number one. Example number one. A Limited holds 60% shares in B Limited. So I can conclude that A Limited is the holding of B Limited. Yes or no? Yes, ma'am. And B Limited, you will be called as the subsidiary. So you are the subsidiary. Subsidiary of whom? Subsidiary of A. Very simple. Yes, ma'am. Obviously, it was very simple situation. Example 2. A Limited controls composition of board of directors of B Limited. So again, I am going to copy and paste. Again, you have to write. Again, I can conclude that A Limited, you are the holding of B, and B, you're the subsidiary of A. Yes or no? Yes, ma'am. Okay. So now let's look at the third example. These two examples were very basic, very simple, nothing new to learn, just exactly what we have read over here. We have read the definition and that's exactly what it tells us about. Now, example number 3. A Limited holds 60% shares of B Limited, and B Limited controls board of directors of D Limited. Got it. A Limited holds 60% shares of B Limited, and B Limited controls the composition of board of directors of D Limited. One is the direct relation of holding and subsidiary that we can very well see is this. By this, I can clearly conclude that A Limited, you are the holding of B, and B, you are the subsidiary of A. Please listen to each word carefully. I know so many times I'm repeating the word holding subsidiary. It might seem confusing. So you have to be very attentive right now. I cannot crack a joke in between such an important concept. You got it? So you have to be very, very, very attentive to listen to this. Okay? So this is absolutely clear, ma'am. We got it. And there is another clear relationship of holding subsidiary which we are seeing over here. Yes or no? So I can also write and conclude that B Limited, you are the holding of D, and D Limited, you are the subsidiary of B. Yes or no? So BD, you have a holding subsidiary relationship. Why? Because there is a control of composition of board of directors. AB, you are also holding subsidiary. Why? Because you hold more than 50% of shares. Yes or no? Yes or no? Yes, ma'am. No problem at all. But is there any relation between A and D? Is there any relation between A and D? No, ma'am. There's no relation between A and D. Okay. Now let's imagine holding to be the father and subsidiary to be the son. So we have we have a father and a son. Okay. Or a mother and a son. So we have Shivangi and we have my son, right? So I am his mother. Now, I have some control over a person. Okay. Because I have lent him, let's say 50,000 rupees. So I keep on telling him, see, you have not paid my 50,000. Okay, today what you do is you come and clean the backyard. Okay. Why? With what right am I able to tell that particular person? Maybe because he has taken some money from him and he's not repaying it, or he's not in a very good condition to repay. So I am somehow controlling that particular person, right? Because we have like that kind of thing. Now I got to know that my son has also given 50,000 to this particular person. Now, do you think I will have double control? I will have double control over this person? Yes, ma'am. Okay. And what about I don't control this particular person? I control my son, and my son has given money to some person. Can I call this person and get the work done? Yes. Why? Because I control my son and my son controls that person. See, it's only for example. So please don't put me in the category, oh my God, ma'am, you're so controlling. You control your son. My son is like barely very, very, very small. Okay. So it's not that. Okay. It's just an example. Fine. So ultimately, are you getting my point? If I control somebody and that person controls the other person, so ultimately I have an indirect control over the third person. Yes or no? Okay. So here, because I control B, B is my subsidiary, and B controls D, right? A is the holding of B and B is the holding of D. So D can be said as indirect subsidiary of A. So A, you become the controller of not just B but also D. So you become a holding to not just B but also D, right? Why? Because you, along with your subsidiary, control D. So A Limited, you become the holding of D also. And D Limited, you become the subsidiary of A also. Got it? Now I am going to give you a challenge. There's another example, and this example is very closely related to what I've already explained you, but then this is a challenge for you to crack. Okay. What's the challenge, ma'am? So note down another example. We have A Limited holds 30% shares of B Limited, and A Limited holds 52% shares in of C Limited, and C Limited holds 27% shares of B Limited. Now you have to tell me the relation. Tell me the relation between A and B, A and C, and B and C, right? These are the three companies we have in picture, and you have to tell me the relation between A and B, B and C, and A and C. I will tell you one. I'll help you. Okay. Basically, because A holds more than 50% shares of C, A and C have a relationship of holding and subsidiary. Holding and subsidiary. A being the holding company and C being the subsidiary company. Yes or no? Yes, ma'am. That's clearly evident and that's very clear. Okay. Now, A and B, do you have any relation? Well, doesn't look like. Why? Because you're holding only 30%. You need to have more than 50% of shares of another company to make it your subsidiary. Or you should be controlling the composition of board of directors, which is not given in the question, right? So we completely ignore that particular part, right? Because you have only these many shares. C and B. C holds only 27% shares of B. So again, how will they establish any holding subsidiary relationship? So they cannot establish. Yes? Yes or no? Now imagine a situation like father and son or mother and son. So A is the mother, C is the son. A gets to know that, okay, I have given this much to B. Oh my God, you also have given this much to B. Which means together we have given this much. Which means together we have given, and we have a control of more than 50%. Why? Because I hold 30% shares and my control holds 27% shares. My son holds 27% shares. Me, along with my subsidiary, which is C, my holding in B Limited plus my subsidiary's holding in B Limited is more than 50%. 30% shares I hold, 27% shares my subsidiary is holding. So together we are holding 57% shares in B Limited, which is more than 50%, and hence there is a relationship of holding and subsidiary between A and B also. Okay, on its own and together with its subsidiary. They don't have any relation. Ma'am, what have you written together with its subsidiary? Come to the definition and you'll understand it. Holding company right now we're skipping and we're straight away going to subsidiary company. Section 2, clause 87. In relation to any other company, of course, it is a relative company. You cannot be a holding company independent of your own. A company in which the holding company. So the other company, if it controls the composition of board of directors, we are called as a subsidiary company, or it exercises or controls more than half of voting power, either at its own. That means I hold directly 51% shares. So I'm holding your subsidiary if I'm a company, right? Or I don't hold more than 50% shares directly, but if I club my holding along with my subsidiaries, so together with one or more subsidiaries, I hold more than 50% control, then also that other company will be called as subsidiary and I will be called as holding. Is that clear? Yes, everyone? Okay. All good? All clear? Fine. Now, why do you think companies actually make other companies their holding? Everyone wants to control the world, right? Why? Why? For two simple reasons. One is to acquire monopoly. That means if I am in the business of, let's say, beauty products and all, and I am like one of the sharks in the shark tank, and somebody walks up with a pitch of some beauty product, I would immediately take the equity and have that particular, acquire that particular business. Why? Because I'm scared. I'm scared and I would want to eat my competitors before they become big enough to compete with me. Yes. So somehow I am trying that, this is an area where I want this brand to rise. So all the small brands which are coming across, I'm trying to acquire the shares and clubbing it, merging it. This is the brand name, or I want to share the profits, even if it is the other brand. Plus the second option, the second reason, we want to explore multiple businesses like Reliance does. Reliance wants to enter into every field. They have not left any field, right? So they see a promising venture, they want to invest and they want to go to that particular field also. So that is why companies make the other companies their subsidiary so that they can control. They're just giving money, investing as it is. The companies are running their businesses, but they have now the control, right? So that is the reason which why subsidiaries are being formed, right? Now, in the entire definition so far, we have a term called as voting power, which we have not discussed. And what is that? Voting power. One simple thing, one simple thing, one simple thing. Okay, let me write an example, although the example relates to what I want to explain you as voting power only, but then you answer. This is again a challenge to you, a question to you. Mr. No, not Mr., but A Limited has share capital. A Limited has share capital. Come on, A Limited has share capital. What is the share capital? The composition is 2000 shares at the rate of 10 each. So it would come out to be 20,000. It could be 20,000 crores. It could be anything, right? Think big. Okay. Now, Mr. X. So there is a person called as Mr. X and he holds 500 shares of A Limited. Okay. And there is another company, B Limited. B Limited holds 1000 shares of A Limited. Okay. So my question to you is, can A Limited be called as subsidiary? Can A Limited be called as subsidiary of B Limited? Yes or no? Yes or no? All those who are saying yes, it's a big no. Why not, ma'am? Why not? Because if there are 2000 shares in the company and I hold, or B Limited holds 1000 shares, that means B Limited is holding half the shares. Can half give you the control? No. The shareholding has to be more than half. Even if it is like 50.00001%, it doesn't matter, but it has to be more than 50%. And it's not more than 50%, it's exactly 50%. So, can A Limited be called as the subsidiary of B Limited? The answer is no. Now, look at the power of DVR. Look at the power of voting power. Okay. What is going to happen now? Just think and imagine. First thing, what is voting power? One share is equal to one vote. Yes or no? Ma'am, we have read one shareholder is equal to one vote. Only when the voting is by show of hands. Right? When the voting is by poll, then one share is equal to one vote. That means if I have invested more money in the company, I will get more rights. Obviously, right? If there are 10 shareholders, all of these 9 shareholders have bought just one share of the company, and I have bought like maybe 29 shares of the company. So I should be getting more right? Now, when the voting is happening by show of hands, all the shareholders have one hand, they have two hand, but like their vote will be counted like one shareholder, one vote. But I'm not satisfied. I'm like, I have invested all the money. They hardly have given any money to the company. I should be taking these decisions. So vote by poll. And now I get 29 votes and they all get just one vote each. So one share is equal to one vote. Agree? Agreed, ma'am. So if I take you back to the example, can I say how many votes are there in total of the company? 2000 votes, because one share is equal to one vote and the company has issued 2000 shares. That means company has 2000 votes in total. 500 votes are with Mr. X, 1000 votes are with Mr. B, and like rest 500 votes will be with other people, right? So what I can say is total votes in a company is 2000. B Limited has 1000 votes. So, voting power of B Limited is equal to 1000 out of 2000 into 100, which is equal to 50%, right? Fine. Since voting power is not more than 50%, it is not a holding company. Yes or no? Yes, ma'am. I don't think there's any confusion so far. Right? Okay. Now, what is, I'll ask you another question. What is DVR? You have read about this before. Differential voting rights. What is DVR? What is differential voting rights? Like, if I am the shareholder of Reliance Industries Limited, and they have given me one vote per share, and I have like maybe 15 shares of this particular company. So every time they have to take a decision, they send me a notice that you can vote. And I'm like, what do I vote? I barely know what is happening in the company. I have not seen it. I have not made my judgments. I don't have the knowledge. I don't have the requisite experience to take these decisions, right? And I'm not even interested. So I skip all the voting sessions that happen. I'm not voting. I'm not participating in voting, which majority of the investors would do. Okay. Now, if this company tells me that fine, I will not give you voting rights. That means if you hold 10 shares, you'll get one voting right. But yes, I will give you double the dividend. I am like, yes, that's my deal. Come on, bring it on. I'm in. Because I don't need voting rights. I need more dividend. Right? Because I have just done it for an investment and I completely trust the management of Reliance Industries Limited. That is why I have invested over there. I don't want the company to rely on my decisions, right? So I'm not a part of voting. Got it? So can this happen? Of course, ma'am, this can happen. That means there could be, subject to the conditions which are mentioned in Companies Act, there could be a case where one share is equal to 100 votes, or one share is equal to 2 votes, or 10 shares is equal to 1 vote, right? Or one share is equal to 2 votes, or 10 shares is equal to 1 vote, right? So there could be any of such combination. Yes? Okay. Now, supposedly, in the previous example, B Limited has DVR shares wherein one share is equal to 2 votes. So a quick recall, A Limited, you have issued 2000 shares at the rate of 10 each. Yes. And Mr. X, you have 500 normal shares. Right. B Limited, you have 1000 DVR shares. And others have 500 normal shares. Okay. So, how do we calculate? Total votes in the company now will be 500 are normal shares, so one share per vote, that means there are 500 votes. 500 shares held by other people, again one share per vote, 500 votes. 1000 shares held by B Limited, and one share means 2 votes, that means 2000 votes. So the total number of votes now has been increased to 3000. B Limited has 2000 votes out of 3000 total votes. Yes, which means 66.67% voting power. Now, B Limited is the holding of A Limited because the voting power exceeds 50%. Yes or no? Yes, ma'am. When there were normal shares, the voting power was only 50% because every share, one share, one vote. But here, when he got those DVR shares, we have seen that now the voting power increased to 66.67%, which is more than 50%. Yes? Yes? So now he became the holding. It became the holding. Okay. So I hope this is clear. Now we have, see, these are the illustrations. You can see it. We have done better and more complex illustrations than this. Now there is one small point, limit on layers of subsidiaries. What do we mean by that? See, layering. We are talking about layering. Layering can be understood as the generations, right? Me, my son's son is the second layer. My son is the first layer. So if I have a son and a daughter, they both are first layer because they are first generation. Next generation is going to be the second layer. That's how it is, right? So if I say, like, maybe you have a company called as A Limited, and A Limited holds 60% shares in F Limited. This F Limited is layer 1. Likewise, A Limited also holds 52% shares in B Limited. Again, B Limited, you are layer 1. Okay. F Limited holds 70% shares in G Limited. G Limited, now you are layer 2. Likewise, there will be layer 3 and so on. Got it? Okay, ma'am. What is the problem? What is the context over here? Why are you even telling us this? Well, here there is no family planning. Okay, so basically you can have n number of subsidiaries that you want to. Reliance Industries Limited has more than 150 subsidiaries, so you can go ahead, right? So you can make as many subsidiaries as you want to. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. But then, if your subsidiaries make further subsidiaries, that means the layering is going on. You have invested in a subsidiary, your subsidiary has invested in another. So that means the source of money gets far and far and far. So you can have as many layer 1 subsidiaries as you want to, that's not a problem. But more than 2 layers is not allowed. That means layering is not allowed. This is completely fine. This could be 1, 2, 3, 4, 5, 6. It could be fine. But then this is not fine. The second generation, the second layer. Till second layer, it's fine. More than 2 layers is not fine. So you cannot have, a company cannot have more than 2 layers of subsidiaries. A company cannot have more than 2 layers of subsidiaries. Provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such number as may be prescribed. No company shall have more than 2 layers of subsidiaries. Okay. Banking, NBFC, insurance, and government, you are allowed to have as many layers as you want to, but other than that, there can't be any company having more than 2 layers of subsidiaries. Earlier, this restriction was only for the investment companies, but now it is like for every company. Okay, now when you will go through these illustrations and example, you might find that there's a third layer also. Ma'am, how is the third layer? It is not allowed. Well, that's only to explain you what is the third layer. If in the real life it is formed now, right, it tries to acquire now, then there will be consequences, there will be penalty. You got that? Okay, and that is something which is not allowed. Is that okay? Fine. Now, when we have read the definition of subsidiary company, the definition of holding company is barely a second. In relation to other company, it means a company of which such company is a subsidiary. So any company which has a subsidiary, to that subsidiary you are the holding. That is it. Not an important definition, never asked an examination. Okay. Now, before I go back to OPC, I want to discuss this concept of associate company, which is again a very short concept, but then let's see this. Associate company. Now, the section number not important. Okay, or that's section 2, clause 6, but not important. You don't need to learn it. Okay. Now, if I take you through the definition, you will not understand much. In relation to another company, of course, it is also a relative concept. That means one will be an associate. Both are called as associate in general, but otherwise it's like investing and associate. But investing term has not been given and defined. It means a company in which that other company. So this is an associate in which that other company has significant influence, but which is not a subsidiary. And having of the company having such influence and includes a joint venture. Okay, so basically we are saying that there is a company and that company has significant influence on another company. So they will have this relation, and this particular company will be called as associate, and this particular company is called as investing company. That's only for your knowledge. We're not reading this. This is what we want to know. Okay, is that clear? Now, I have told you that look at the couples, right? You will see a very person who is very controlling. Usually they're like husband and wife, right? So you'll see wife having that super control, all in the fun and the light mode. Okay, because one day, maybe 10 days late, 10 years later, you will also get married, right? And after marriage, the things are very different because you have to look at the priority of your partner, right? So maybe your wife wants to have and enjoy a meal of Chinese. You cannot say that today I want to go for South Indian food, right? So that is how the things turn out to be. I'm not trying to scare you. It is a beautiful relation, and I'm sure you'll find full contentment in that. But on the fun side, yes, at times this is the reality which hits, that you are being controlled because all your freedom is gone, right? So if A Limited holds 60% shares of B Limited, we can say that they have a husband-wife relationship or a holding subsidiary relationship, because here is full control. Yes? Okay, ma'am. If I say that A Limited holds 50% shares of B Limited, is it holding subsidiary? No, it's not holding subsidiary. Is it having significant influence? Ma'am, what is significant influence? You haven't even told us. Well, significant influence, although you are not supposed to actually read it, but it means having more than or equal to 20% of shares. That means one company has 20% shares of another company, that is associate. One company has 50% shares of another company, associate. One per company has 51% shares of another company, subsidiary. Got it? So this is like your girlfriend who has very strong and significant influence but does not control you in entirety, right? So this is like significant influence, and this is associate. Okay. Likewise, if we have A Limited, you hold 20% shares, again you will be called as associate. Okay, supposedly we have a company A Limited and it holds only 10% shares of B Limited. It's not a holding subsidiary. To become a subsidiary, you need to hold more than 50% shares of that company. Is it an associate? No, because to make it an associate, you need to have a significant influence, which means at least 20% shares of that particular company. Here, you are holding only 10% shares. That means it is like your crush, maybe, no relation, only in dreams, not in reality. Got it? So I hope you understood what exactly we mean by the term associate, right? Okay. So this is also clear. Now we come back to our one person company. One person company, section 2, clause 62. One person company, which we commonly, popularly, and lovingly called as OPC. Now, it is although one person company, but because it is a private company, the section number, you can remember it as section 2, clause 62. Ma'am, is it important? Not as important as the section number of private company and subsidiary. So that is always your priority. Okay. OPC is nothing but is a type of private company. It is nothing but a type of private company with special features. With special features. Okay. Now, whenever people talk to me about one person company, I'm like, it is a South Indian movie. What are you saying, ma'am? Yeah, in mostly South Indian movies, now they have been copying. Bollywood has been copying Tollywood big time, right? So now you will see in North Indian movies also such type of scenes. But earlier it was like a forte of South Indian movies where they have like one man army. One person can destroy the entire world. Yes or no? Whether you take it KGF, Pushpa, whatever you may call it, right? Can destroy the entire world. Although when I talk about body corporates, like big fancy terms, you need people, you need army, you need strength to run a company, yes or no? But here, there's just one man. We have seen very big shot examples also who started with one person companies and later they have converted their companies to private and now to public and they're like big companies, right? There's just one person who has a good dream, vision, idea, but he does not want any conflict. So he does not want to find any other person to accompany him. He's like, I'm sufficient. He has money also. So he invests maybe 1 lakh in a company. Now he doesn't have any other person. So now Companies Act 2013 gives a beautiful opportunity to all these budding entrepreneurs. The ones who were actually running their proprietorship business and facing the consequences because of the disadvantages that they do not have the feature of limited liability, perpetual succession. So now they have a company where the liability gets limited. They are not personally liable for the things. There will be perpetual succession. It is more corporate and organized structure. So they get more access to banks, right? If they go to a bank and it's a company, it's a registered company which has more value, which has more goodwill, right? So bank will lend the loan easily than to a sole proprietor who goes and connects with the bank unless he has some different connections, right? So every opportunity gets better, everything gets better. So it's a beautiful thing which has been done. Okay. So one person company, all you need is one person. So, ma'am, he is going to be the shareholder of the company. Yes or no? Yes, ma'am. He's going to be the sole shareholder of the company. Can there be 2 members in OPC? No. There has to be minimum 1, maximum 1, only 1, and only 1. Okay. Ma'am, we are saying one person. When I say one person, and if I have read tax before, I know that person could be an individual, HUF, body corporate. Yes or no? That means anyone can form OPC. Anyone can form OPC. Well, no. Although person can be male, female, company, HF, etc., but not in India. In India, it is only only a natural person. Only a natural person. Natural person means, of course, you could be male, female, even transgender, right? So they can form OPC. Only a natural person. No artificial person is allowed to form OPC. Now, if I ask you, listen, okay, listen to me very carefully. I'm asking you a question. If I ask you, can ABC Limited be the holding company of ABC Private Limited OPC? Yes or no? No, 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 no. Because this particular company will just have one shareholder. It cannot have more than one shareholder, and that one shareholder has to be the natural person only. It cannot be a company. So OPC, you can never be a subsidiary of any company. Why? Because the shares that are within you can be held only by a natural person. You cannot be the subsidiary and you can also not be the holding. Why? Because it is not permitted. You cannot invest in the shares of anybody corporate. So, if I sum it up, OPC cannot be a holding or a subsidiary. OPC can't be a holding or a subsidiary. Fine, ma'am, we get it, no problem. That means you are a small entrepreneur and you were doing some proprietorship business. This gave you an opportunity that we have now OPC. You can convert your business, you can shift your business and form an OPC. Okay, fine, I did that. I'm a natural person, or Mr. X is a natural person, and Mr. X has wonderful ideas and he formed a company. Okay, no problem. But now he has to go somewhere to UK and someday to maybe Europe and someday to Australia, someday to China. Like, he travels a lot. And he stays in India only for 90 days in the financial year. That means if I sum this up, he's not a resident. He's not a resident. Can he still form this OPC? Yes. Yes. Only a natural person, whether resident or not. Whether resident or not. Please mark my words, there could be error even today in the material when this amendment has come long back. So a natural person, whether resident or not, can form OPC. Ma'am, does he need to be the citizen of India? Yes, citizenship is important because you're registering the company here, so you are the sole person, so he must be citizen of India. He must be citizen of India. So only a natural person, citizen of India, whether resident or not, these are the three conditions. These are the three things. Okay, can form one person company. Okay, ma'am, Mr. X formed a one person company, but then after an year, he died. He died. Now, because you said one person is sufficient, he invested in the company. He was the sole shareholder and he did not want anyone else to manage his company. So he was the sole director also. He was the sole director also. For all those who do not know this, minimum number of members in OPC is 1. Maximum number of members in OPC is again 1. Minimum number of directors in OPC is 1 and maximum number of directors in OPC is 15. OPC can have more than one director. It cannot have more than one member, but it can have more than one director. So maybe Mr. X formed a company and he hired or appointed or elected 3 directors who are working, fine. But it could also be the situation that he decided that I will be the sole director. I myself am going to manage the entire company. He can do that. So he was the sole shareholder. He was the sole director. And he was unmarried. Okay. So what happened when he died? What about the perpetual succession? How will the company be picked up? Ma'am, even in case of private company, if there are two members, both of them dies, what happens? The shares are transmitted to their legal heirs. In a private company, there are first of all two members. There will be the two legal heirs. There will be two directors, right? So there are more members to look at, and it is very rare that all of them are going to die at one place. But in OPC, it may so happen, and in such a situation, there it will be very difficult for the company to revive and run, and that is why the concept of perpetual succession may be lost. To solve this situation, Mr. X, you need to appoint a nominee. Mr. X, you need to appoint a nominee. Okay, there are more to it. Trust me, there are way more things which I want to tell you. In fact, just a second. Although we'll be reading more about OPC when we talk about incorporation of a company, but right now, what I can tell you is that OPC is very similar to doing marriage. What are you saying, ma'am? Yes. In OPC, you have to find a nominee. Yes or no? Okay, ma'am. In marriage, you have to find a girl. Now, when you find a nominee, can you just write the nominee's name and that will be the nominee? Ma'am, what exactly a nominee is? Nominee is a person. Like if Mr. X has a very great business idea, he decides to form one person company, he registers it, he is the sole shareholder, he is managing it as a director. But what if someday he dies or becomes incapable to enter into a contract because of unsound mind or something like that? What will happen to the company? So he gives a name of the person who is going to take his place. That means that person will become the sole shareholder and will now manage the company, will now run the company, will now be there, right? That could be his relative also, sister, father, brother, friend, any person. But again, that same person has to be natural person, citizen of India, whether resident or not, and of course, major. A minor cannot be the nominee. Nominee also, a minor cannot be the nominee. Okay, because he should be capable to enter into a contract. A minor is not capable to enter into a contract. Okay, so you have to find a nominee. Now, even if I find a nominee, Mr. X thinks that, oh my God, this friend is wonderful, right? If at all something happens, this particular person can take over the company. But that person is not ready. So can you make that person a nominee? No. So you have to obtain consent of nominee. Obtain consent of nominee. Here also you have to obtain consent of girl. Now, okay, fine, you obtained the consent, but later on you found that, oh my God, where am I trapped? This particular person is not fit to be the nominee. So you can replace the nominee. Can you? Yes, why not? Can you replace the girl? Why not? Till the time marriage is not taking place, you can replace the girl also. And the girl can also go and run away, that this man is a big red forest, right? So that girl can also withdraw consent. Withdraw consent till marriage. After that, there will be divorce, right? Here also, that nominee has the power and option to withdraw consent. Withdraw consent till he becomes the member. Yes or no? Okay. Now, let's come to OPC. One person company means a company which has only one person as a member. It is basically a private company with some unique features. Okay? With some unique features. How it may be formed: a company limited by shares, or a company limited by guarantee, or an unlimited company. So these are the three ways it can be formed as. Only one person as member. Minimum paid up capital, no limit is prescribed. Memorandum of OPC will have the name of that nominee who will become the sole shareholder if the subscriber dies or becomes incompetent to enter into a contract. The person whose name you have written as nominee has to give his prior consent that he agrees to be the nominee. That particular person can withdraw their consent whenever they want to. You can change the name of that nominee whenever you want to and intimate the same to ROC. Okay, fine. Now, who can form OPC? Only a natural person who is an Indian citizen, whether resident in India or not, shall be eligible to form OPC and be the nominee of OPC. Okay. Now, you cannot carry out NBFC activities or invest in any body corporate. Okay. Penalty I'm not discussing right now. You don't have to get into that right now. Such company cannot be incorporated or converted into a company of Section 8. We will read about the Section 8 company, and that time I will tell you, you cannot convert OPC into Section 8. Okay. You cannot incorporate Section 8 company as OPC. Section 8 company is the company formed for charitable purposes. Minor cannot become the member or nominee of OPC. You cannot incorporate more than one OPC or become nominee in more than one such company. Is that okay, everyone? So far, are we good? Okay, this point I have to elaborate and I have to tell you more than that. But before that, I want to tell you this also. Who is a resident? A resident is somebody who has stayed in India for at least 120 days. Now, you might be of the view, ma'am, here it is 120 days. In tax, we have read something else. In FEMA, we read something else, etc., etc. So, what is exactly that we need to remember and learn? For this particular purpose, for law, you have to remember 120 days only, although it is irrelevant, because even if you are a non-resident, still you can form OPC. But still that they have defined who a resident is called. Okay, so it is not something which holds a lot of importance, but for here, you have to learn and remember 120 days only. Okay, fine. Now, supposedly we have Mr. X. Mr. X forms one OPC. Can he form another OPC? No. He cannot be a sole member of two OPCs at the same time. Okay. Now, he becomes nominee of ABC OPC. This is PQR OPC. Can this be possible? Yes. You are the sole member of one OPC only and you're also the nominee of one OPC only. You're not a nominee of two OPC. You're not a member of two OPC. Right? So you are a member of one OPC and a nominee of one OPC. This is allowed. This is allowed. But then if sole member of this OPC dies, Mr. X becomes the sole member of ABC OPC also. Yes. Now, at one point of time, he is the member of this also and this also, which is not allowed. At any one point of time, you cannot be a member of two OPCs. So, he has to choose one OPC from PQR and ABC within 180 days. So he will decide which OPC he wants to continue as a sole member. Okay, right now you keep in mind all these points. Later on, when we do the incorporation part, we will discuss more about the advantages, benefits, everything. Okay, is that fine? Okay, so revise well whatever I have told you. Today I've not given you any homework to write the questions because right now we are like in the basics only. But please revise it well. Fine, see you in the next class. Thank you.